Continuing on this episode of Law Weekly, a discussion on some of the fallouts of the presidential and National Assembly elections. We have the views of a senior advocate of Nigeria, Adeyinka Kutoye. Also showing on the program, human rights activist Fumi Falana uses the opportunity of the celebration of the International Women's Day to again make a case for the implementation of 35% affirmative action in appointments of women into public offices, plus a recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Sheli. There has been a robust debate on the provisions of Section 134, subsection 2B of the Nigerian Constitution, which provides that a candidate for an election to the office of president shall be deemed to have been duly elected where he scores not less than 1/4 of the votes cast at the elections in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. I got my guest, Adeyinka Kutoye, to also weigh in on this and other issues.
I think that section is very clear and unambiguous. I have read and listened to so many interpretations of that section, some of which I consider partisan. But I'm of the view that the key word there is "and." Says the 36 states of the Federation and FCT Abuja. When you look at the definition of "and," it means something in addition to or apart from, which to me presupposes that apart from having 25% in 24 states, you must also score 25% in Abuja. And there are so many authorities on this point that had interpreted the word "and." I'm also not unmindful of the cases of Buhari and INEC being bandied around. But you discover in that case that the issue of whether now President Buhari scored 25% in Abuja never arose. They were only looking at the status of Abuja vis the administrative structure. I'm also aware of the Bakari and Ogundiman Bakari case, which some people also had been throwing around. In that particular one, too, they were only looking at the administrative structure which Section 299 created and which made Abuja an administrative center as it was intended to be from the beginning. So to now read Section 299 into 1342B, in my own view, is expanding or imputing into what is not in Section 1342B into it. So since the words are very clear, we use the literal rule of interpretation. And since the latter part of that provision specifically mentioned Abuja, it means you construe it in such a way as to exclude the 36 states earlier mentioned. So my own position, subject to what the courts eventually decide, is that you will need the 25% in Abuja in addition to scoring 25% in 24 states.
But what about the argument that it was not the intention of the drafters of the Constitution for Abuja to have a special status?
I don't subscribe to that perspective as well. As far as I'm concerned, Abuja has not been given any special status by virtue of Section 1342B. We have similar provisions in the 1979 Constitution, but they did not include Abuja. We have similar provisions in the 1989 Constitution. It also did not mention Abuja. However, you will see that because of the 12 to 3rd crisis, which the Section 126 of the 1979 Constitution threw up, they tried to cure it in the 1989 Constitution by saying that in a situation where there is a fraction as we had in 79 in Kano in 79, that where there is a fraction, it will be appropriated to the next nearest figure. You could see that the intent of the drafters of that particular section was to cure the crisis that arose from the interpretation of the 1979 version. In this instance, as at the time the 1999 constitution was done, the Federal Capital Territory had already been moved to Abuja. Under the 1989 and 79 constitutions, the Federal Capital Territory was still in Lagos. And of course, Lagos was also listed as one of the states of the Federation. However, by the time the 1999 constitution came into being, Lagos had ceased to be the Federal Capital Territory. It has now become Abuja. So there is a need to include it, not to create a special status. It was just an inclusion, to include it and expand the previous similar provisions in 1979 and 1989 to include Abuja. And let me give you this. Go to the definition sections of the Constitution where the states were listed. Abuja is not listed as a state. So, for all intents and purposes, I can't think, and I won't subscribe to the view that the drafters of that section intend Abuja to be read together with the other 36 states.
Anyway, like you said, we'll wait for the courts to decide on that. But one other issue that the presidential and National Assembly elections threw up is the issue of the electronic transmission of results from the polling units directly to the INEC's IREV. Looking at the provisions of the Electoral Act, what effects do you think that delayed transmission will have?
As a matter of fact, I am unable to see how the delay has occasioned any injustice from my perspective and from where I voted. But I've also come to hear and read of complaints of situations where those results were not uploaded at the polling unit. I've also read, I believe it is true, the comment attributed to the INEC chairman that it is not compulsory that those results be uploaded at the polling unit. I am however unable to agree with him because my own view about Section 61 of the Electoral Act is very clear, though it also now gives the Commission the liberty to prescribe the mode of transmission. But in doing that, the Commission will also have to be guided by its own guidelines. If you read Section 34 to 38 of that guideline, it clearly states the mode. And I don't think the chairman will be right to say that it allows them to do things which are outside that Section 34 to 37 of their guideline. Because when you read that section clearly, you will see that it says, upon the conclusion of poll, the presiding officer will do this, it will do this, it will do this. But where it is not possible, he will now use the manual transmission and take it to the collation center. Okay? Now, in doing that, you now have to give us a report. I'm talking as a litigation lawyer now. For you to say, factually, you were unable to do it because of so reason, I must see the report from the presiding officer of that particular unit, which says, oh, either beavers didn't work, or the network was bad, or for some security reasons I could not do what I've been asked to do by the guideline. Unfortunately, that's not the result that we have. So for me, it will be too adventurous to subscribe to that view that it is not necessary to post or upload your results at the. After all, what is the essence of the beavers? And I'm sure one of the things they sold to us when they were pushing the idea of the beavers is that it allows for electronic transmission of results. And wherever you are, so long as you can key into the IREF portal, you'll be able to access the result from each polling unit. So that's why I find it difficult to subscribe to his position.
But when you talk in terms of the law, would you say that there's been substantial compliance with the provisions of the Electoral Act?
I think INEC still owe us more explanation that they had done. Because as at Sunday, like about 6 p.m. and up till about 9 p.m.
Sunday, February 26th.
26th, I heard the chairman in one of his media briefings saying that out of the 173 or 177, 76,000 polling units where elections were conducted, they've only been able to upload 65,000 polling units. And for that reason, they are experiencing some glitch. Okay? However, from the proceeding, one could see that they were nearly about 1/4 through with the result as at Sunday. So question, what happened to the remaining 100 and something thousand polling units results that were unable to be loaded onto the portal? So it is for the chairman.
They actually have some of them have subsequently been uploaded.
That was after the declaration had been made. Yes. Okay? Now for transparency and for credibility, I think before that declaration, everybody should have had access to the results so that it will be clear, even to all doubting Thomases, that INEC was open and was available, accessible. It is not just enough to conclude and expect people to believe you, especially in such a technical society as we have, where trust is a big issue, that because you had that glitch and you are unable to upload at that particular moment, therefore, what you had done should be accepted. There will still be that doubt. And I'm sure that was the major focal point for the international observers, because I read the report from the EU and I read the report from the AU team as well. That was their focal point, that transparency, clarity is an issue. Because as a matter of fact, nobody had access to those servers. You are the only person who has access to it. You are the only person who knows what is wrong with it. But because you are a public institution, decency dictates you explain to people. And maybe for a reason you tell them, okay, this is the one we've been able to collate so far, and this is how far we can go. We're having this issue, this issue, this issue in this area. It may not be their own fault. It may be as a result of third-party interference. But hold on, let us hold on to this process. We'll try and sort out the issue, and we'll come back in another 3-4 hours. That was not the kind of explanation we had.
Let's move on now. I want to talk about something else that's equally topical. On Thursday, a federal high court judge ordered INEC to allow 2 applicants who went before the courts to be allowed to use their temporary voters card to vote. But INEC, of course, has said that it would appeal that judgment. So what do you make of that order? And what do you think that other persons who have similar issues can benefit from that order?
That temporary voters card was supposed to be temporary. And I think everybody was given sufficient time to go and exchange it for the permanent voters card. I think the temporary voters card was the one used in 2011. So if by now you haven't changed it into your permanent voters card, I don't see how you can hold INEC responsible for it. I'm not holding forth for them. And I'm not saying what the judge decided was wrong. But for me, I do not see the logic. Unless if you are able to show to me how you have been disenfranchised or what particular injury you had suffered.
Finally, Leonard Silk, attention has now shifted to the courts. There are a lot of cases in courts from the fallout of these elections. And some people have said that the judiciary has no business determining winners of elections, because it appears that we now have a lot, what some people will call court-appointed winners. What do you make of that?
we should all realize that the judiciary is our last hope. And if by error of commission or omission, we destroy that temple, it will be an easy recipe for crisis and chaos. An example is the recent currency swap case. And you see the way the Supreme Court came in to provide a soft landing for the presidency, although unfortunately they didn't seize the advantage. We should realize that the courts are there to administer justice based on facts presented before them. Do you know the reason why they put a blindfold to my Lady of Justice? They are supposed to close their eyes and their ears.
I like that you said they are supposed to.
Yes. They are supposed to close their eyes and their ears
So that they can do justice.
so that they can do justice the way they see it, without fear or favor. Now, when you start clustering them with blackmail, smack remarks, they are human beings like you and I. They read papers. They also go online. If they don't, their children do. We need to be fair to them.
Away from that interview and as part of activities to celebrate the International Women's Day, Lagos lawyer and human rights activist Mrs. Fumi Falana has again made a case for the implementation of 35% affirmative action in appointments of women into public offices. She spoke at a program organized by the Women Empowerment and Legal Aid Wella in Lagos. We have details in this next report.
The International Women's Day is celebrated March the 8th every year. This year, the theme of the celebration is Digital, Innovation and Technology for Gender Equality, which is designed to help women play fair roles in technological development of the world. Like previous years, Women Empowerment and Legal Aid Wella is also celebrating the day. The celebration held at its Empowerment Center in the Agege area of Lagos attracted these lawyers, students, and others.
For 5 years, I've realized something.
Wella is a non-governmental organization committed to empowering women. At the Empowerment Center, over 150 students have been trained on different vocations which will make them independent. This occasion provides an opportunity to showcase the achievements of the students and their teachers. Some of the students also entertained and informed the audience on some of the ills militating against women in the society and how it can be addressed. The founder of Wella, Mrs. Fumi Falana, says she is confident that the inspiring stories of the students will demonstrate the positive impact and importance of empowering women through education and entrepreneurship. She also uses the occasion to remind the government of the need to enforce the judgment of the court, allocating 35% of political positions to women.
Recently, I'm sure you still remember, Willa went to court. Willa and 15 other NGOs went to court in 2022 to challenge the appointments that there should be at least 35% affirmative action that will be given unto women. The role of women is such that a woman must be given equal opportunity and, of course, equal appointments in positions of decision making. And so we challenged the appointment that was done in the year 2021, and we went to court, and the court held that there shall be 35% of the positions of decision making in Nigeria allotted to women. Of a fact, if you look at the political scene, you will see that of all the 36 states, none is a woman, no governor is a woman. And I think out of about 107 in the Senate, we have just 7 women. That is not good enough. So we are saying women should be included in appointments and, of course, in decision makings in Nigeria. I have said it sometimes that the way our politicians play politics is such that they make it difficult for women to participate. Most of their meetings are held in the night, nocturnal meetings. And you will agree with me that most women will want to be at home with their children about this time. So we discovered that as they hold their meetings in the night, they exclude women. And in their political parties' appointments too, they usually will reserve only one post for the woman, and that is women post, a women leader, where they share other posts among themselves, forgetting the fact that the bulk of voters, of course, are women. And when they go for their campaign, it is women they will use. They give them Ankara, 4 years Ankara, and that is all they get from them. When they have to share positions and appointments, they exclude women. But when they need to dance and campaign, they include women. When they want to hold their meetings, they hold it in the night, nocturnal meetings, such that most women will not be able to attend. So these are the things that make it very difficult for women to be very vibrant in political scene.
And just before we go, a recap of some of the top trending stories in the news.
We begin with the report that a three-man panel of the Presidential Election Petition Tribunal sitting at the Court of Appeal in Abuja has granted the request of the Independent National Electoral Commission to reconfigure the bimodal voter accreditation system it used for the February 25, 2023 presidential election. The court, in a unanimous decision by the panel, led by Justice Joseph Ihe, held that the backup files on the server cannot be lost and that preventing the electoral umpire from reconfiguring the BVAS would be adversely affecting the governorship elections. The court also ordered INEC to allow the president-elect, Senator Bola Tinubu, and the candidate of the Labour Party, Mr. Peter Obi, access to sensitive materials used for the presidential election. The three-man panel said it was satisfied that there was merit in the request to have access to the electoral materials. At the Federal High Court Abuja, Justice Obiora Egwuatu has ordered the Independent National Electoral Commission to allow the use of temporary voter cards in the March 18 governorship and assembly elections. The judge made the order in a suit filed by two concerned Nigerians seeking the use of TVCs in the general elections in the absence of permanent voter cards. Justice Egwuatu says that the order was made on the grounds that the plaintiffs were duly registered and captured in INEC's database. The judge, however, said that he was unable to grant a third request, which was to allow every eligible voter with a TVC to vote because the suit was not filed in a representative capacity. In Imo State, a magistrate court sitting in Owerri has remanded the former Deputy Governor Gerald Iroha in the Owerri Correctional Center on a 3-count charge bordering on treason, illegal possession of state government property, and for making utterances capable of causing unrest and chaos. The presiding magistrate, Chike Ezerioha, ordered his remand pending when the issue of bail is heard and determined by the State High Court in Owerri. In her ruling, the magistrate agreed with the prosecution counsel that she lacked the jurisdiction to entertain the matter or grant the accused bail. She ordered that the case file be transferred to the State Department of Public Prosecution to enable them take the next legal line of action. At the Federal High Court, Port Harcourt, the police have arraigned a member of the House of Representatives, Chinyere Igwe, who was arrested with a huge amount of money in dollars on the eve of the presidential and National Assembly elections in the state. The lawmaker, who represents Port Harcourt Federal Constituency 2, was said to be arrested with the sum of $498,000, an amount the police said constituted a money laundering offense. He pleaded not guilty to the 1-count charge. The presiding judge, Justice Stephen Dalopam, thereafter adjourned for consideration of bail. The judge also announced May the 4th as the date for the commencement of criminal trial. And we round off with the report that the Federal High Court sitting in Lagos and the Federal High Court in Abuja has given conflicting judgments on the electronic transmission of results. In Lagos, Justice Peter Lifu ordered the Independent National Electoral Commission to directly and electronically upload the results of the March 11, 2023 governorship and State House of Assembly elections in Lagos State from the polling units to the IREV. Justice Peter Lifu granted the order while delivering judgment in a suit filed by the Labour Party and 41 others in which they sought an order of mandamus to compel INEC to obey the Electoral Act and its guidelines for the conduct of the elections. The judge held that the court possessed the jurisdiction to entertain the suit because it was commenced in accordance with the provisions of the law. He noted that all the applicants were trying to do is to compel the electoral body to comply with the Constitution, its regulation and guidelines, which it failed to do during the presidential and National Assembly elections held on February the 25th, 2023. But in Abuja, Justice Emeka Nwite dismissed the suit by Labour Party on the same issue. He held that INEC is at liberty to prescribe or choose the manner in which the results would be transmitted.
And that's the program this week. Many thanks for watching. Don't forget that you can catch a repeat of these or past episodes on our YouTube page. Feel free to also share with us your comments on any of the issues we discussed today. I'm Shola Shieli. Thank you for watching and see you next week.